Welcome to a special industry-exclusive Weekly Friedman. Last month, the American Institute of Servicing and Legal Executives, or AIL for short, filed an amicus curiae or friend of the court brief on a New Jersey state court foreclosure matter, PNC Bank v. Capellecchia. The Capellecchia case is pivotal for the Community Wealth Preservation Program, and the court's ruling will have a major impact on how the CWPP operates going forward. The Community Wealth Preservation Program has been the subject of numerous Weekly Friedmans and will likely be the subject of a few more in the future. But today, we're veering off the topic from the bill somewhat, and we'll focus more on AIL's amicus brief filing and the practice of filing amicus briefs in general. Today, I'm fortunate enough to be joined by my good friend, Cade Holleman. Cade is the Chief Development Officer at Padgett Law Group and a co-founder of AIL, an organization of which Friedman Bartolo is a founding member. How's it going, Cade?
I'm doing great. How are you? Thanks for having me.
Doing pretty good. Thanks so much for joining me. I know you're a busy guy, and I really appreciate you making the time. So look, there are a lot of important issues in our industry. How does AIL decide which issues or legislation are most important and warrant an amicus brief?
It's a great question. At AIL, we really take two paths to our approach there. One, top down on federal issues, but when it comes to state issues, we rely heavily on the AIL membership. The firms that are in AIL devote much, if not all, of their practice to default servicing or creditors' rights. And many of them have multi-state practices. And so when they have market share, the internal resources, and the talent in-house to carefully and thoroughly evaluate the issues at their respective state houses, we lean on that, and they often bring those issues to AIL when they rise to a particular level, or if they present such a risk to the industry that we should take proactive action. Sometimes we identify and take the issues to members directly, but I would say 80% of the time, these are member generated. In my opinion, that alone gives an issue high marks because it means a firm is already identified and considers it worthy of weighing in on. I mean, remember, foreclosure and related legislation, it's state specific, often even within that state, jurisdictionally specific. So who better to know the impact and importance or the risk of a given issue than a boots on the ground firm like your own?
It's a good point. Obviously, attorneys and law firms are following these issues regularly, and it makes a lot of sense to be leaning on that expertise. Let's pull the curtain back a little bit. So the Community Wealth Preservation Program is clearly a really big hot button topic, right? Especially in New Jersey. How does AIL decide which case you're filing a brief on? Is that something you're leaning again on your members?
Yeah, so to answer your question from a process perspective, the issue typically comes in from one member in a given jurisdiction, which we then run by the other law firm members with a practice in that state. More often than not, the members agree, and we task the initiating firm with being the primary drafter. In those instances, other firms can contribute, they can weigh in, some may even abstain from participating, and sometimes they just want to cheerlead, and that's fine too, as long as we can get the brief over the finish line and filed in a timely manner. As you know, these opportunities, they often come with very tight deadlines, so we're always appreciative of firms who bring the issues, craft the arguments, and move the brief forward so we can get them filed. In the instance of the CWPP, your firm, Friedman Bartolo, put the issue on our radar, and it's one of those issues where once we dug in, it was clear to us that we thought the court should hear and would benefit from hearing a different perspective.
So the list of organizations impacted by this bill is endless, but AIL's the only one to file an amicus curiae brief. What do you see AIL's role in the default community? Where do you think you guys fit in?
That's a great question, and I appreciate the opportunity, honestly. We're a think tank, first and foremost. That means that we're a pen to paper type of organization. So I'm thrilled to hear when we're out there in front on a given issue, whether it's a state bill that may have unintended or even intended consequences that harm or hinder our members or clients. To me, it's critical that AIL be balanced in its approach, fair and considerate of the various stakeholders, and realistic about the outcomes. The nature of our business is economically necessary, but it can and should be ethical, compliant, and considerate of the facts. What our members do is just one part of the housing life cycle, But it's important that we keep our focus on our clients, their customers, and the communities that are impacted. If we work together, think carefully about the process and the outcomes, and care about those things, then I see ISLE being an incredible force for good, common sense, regulatory and legislative change that's reasonable and fair.
I'm a fan. Our whole firm, we're all fans. I think what you guys are doing is great. And look, I really appreciate you coming on today. I know you're a busy guy, and I really appreciate it. So thanks a lot.
Thanks for having me. It's a pleasure. We appreciate everything you guys do in the market and what you do as an ISLE member. And I look forward to working with you guys and your team more in the future.